And joining us in studio, Oliver Dixon, social political analyst, and Botsang Muila, political analyst, and Mr. Paul, Advocate Paul Ngobeni, legal expert. Thanks so much for your time. Good evening, Mr. Dixon, and thanks so much for joining us. Just looking at, I mean, of course, this has been a long-standing case, and we know that the President Zuma wanting to interdict the case, all of that Judge Mlambo had to make in setting aside certain of Zuma's interdicts. Where does this put us now in terms of the executive constitutional prerogatives of the president?
Unless President Jacob Zuma has been pulling wool over our eyes, he's always been very willing and made it clearly and expressed it very clearly that he's never been opposed to setting up a commission of inquiry. His concern has always been that in doing so that there shouldn't be judicial overreach, that the powers and duties of the public protector and I guess Chapter 9 institutions by extension thereof should be clearly defined, and that there shouldn't be a stepping on toes thereof. And he's always spoken quite clearly about how he thinks the terms of reference should be clearly defined as to what the scope of this inquiry will be. In his second last visit to Parliament, President Cyril Ramaphosa confirmed that President Jacob Zuma is working very hard at setting up this commission of inquiry, that he's working very hard at getting a team to really look into what the terms of reference for this inquiry should be. So I'm very convinced the president has always had the attitude of wanting to appoint a commission of inquiry. I think procedurally we needed to follow due course. However, and it's quite interesting that the judge in this instance, Judge Mlambo, made a value judgment on the substantive material of the report when no one asked him to. No one asked him, do you think that the extent of the recommendations given by the public protector are correct? All they were asked is it within the powers of the public protector to dictate to the president to appoint dictate to the president what to do in this instance, not to tell us, hey, do you think it's a nice thing that this inquiry must be set up? And the judge went in his judgment and gave us a value judgment thereof. So it clearly set the wrong tone and seems like there's something wrong here. But I do believe in our judiciary. So I believe that if this call is the wrong one, that the president should by all means appeal. And if it's the incorrect one, a higher court will turn it over.
Yeah, but what are the prospects of success in an appeal? We always ask from our legal expert, Mr. Ngobeni, if you can shed some light there, and whether the extraordinary circumstances of the president being implicated and therefore conflicted, as the judgment stipulates, that he is not fit to appoint an independent judge for the inquiry.
Well, I think if the president was to appeal this particular judgment, his prospects on appeal are very good. What we need to focus on, and I think this is where one of your panelists has correctly noted, that the judge seemed to be making value judgments about questions that were not actually before the court. It seems to be that he is focused more on whether there is some kind of credibility to what the public protector said, rather than looking at the question that was before him, whether or not consistent with Section 84, subsection 2F of the Constitution, the power that the Constitutional Court has said vests in the President and in the President alone, whether that power, whether it's correct to have that President abdicate that power and have the Chief Justice assume powers that the Constitution reserves to the executive. On appeal, the issue that can be presented, or that must be presented to the court rather, is whether, given that a commission, and if you look at our Constitution, you look at precedent all over the world, commissions of inquiry are merely appendages, policy appendages for the executive to inform itself of certain facts and to obtain recommendations, typically from experts who might have more insight into matters than or have more expertise than the executive has. And also what's important is that the president, and this is, I'm quoting directly from what the Constitutional Court said, the president is bound neither to accept the commission's factual findings, nor is he bound to follow its recommendations. So after all this rigmarole, going through, making arguments about whether the public protector was correct to say that the Chief Justice must be involved and all of that. At the end of the day, the recommendations of a commission go to the executive, to the president, and he's not bound to accept its factual findings.
All right, Mr. Ngobeni, then if these are not, the commission, as you're saying, and its findings are not legally enforceable, what is the point of it all?
Well, normally, this is why the Constitution reserved that power to the president. Normally, when some alarming event takes place or something that causes public consternation, the executive might find it necessary to set up a commission of inquiry. I mean, we have had disasters in this country, like you look at the Marikana Commission of Inquiry. You have had persistent allegations regarding the arms deal. You had the Seriti Commission of Inquiry. All of those things are merely appendages, the executive appendages that the executive sets up a commission to get better advice and recommendations on matters. It's never meant to alter the president's power under the Constitution, because at the end of the day, the recommendations come back to the president. They are not binding. He's free to reject them. And that has happened in South Africa before. I mean, you remember the Chinola Commission of Inquiry, which President Motlanthe rejected some of the recommendations, including the reinstatement of Advocate Pikoli. So it's simply a political statement. This judgment, when you look at it, at the end of the day, you ask yourself, how is it possible that you can say the president, who's ultimately going to be the person to decide whether to accept those recommendations or to implement them, that he's not qualified to appoint a commission? And he's not qualified to appoint a judge who will be independent. The president's role, actually, once the commission is appointed, an independent process, that is where you have evidence leaders, you have a judge who's not beholden to the president in any way, make the inquiry, and then come up with recommendations and findings. Those recommendations and findings are then given to the president, who is free to reject some or all of them.
All right, please stay on the line. Mr. Dixon, this obviously seems like a vindication for the erstwhile public protector, Advocate Thuli Madonsela, in the sense that she had labored the fact that she's under-resourced, doesn't have the capacity in terms of staff, and that her term was coming to an end, and she needed to finalize this report and not hand it over to Advocate Mkhwebane. The judge saying that this is also to avoid the incumbent to have to start all over with the investigation. What is your view on that particular item?
Substantively, I think there's some very beautiful things about the state of capture report. One, it gives us an opportunity to now really have a conversation about state capture in this country. And that's one of the things the president said he's looking into, the terms of reference. Where are we looking, defining, first of all, what state capture is. And by that definition, we look across the scope of governance, of government's work, across the scope of the private sector's work, and see who fits that definition. And all of those entities that fit it will be investigated. And I think that's a beautiful thing to do in our democracy today. So I do think that the public protector did some beautiful work in that instance. However, I do think clarity is needed as to what the extent of the public protector's powers are, right? That's not to say the public protector is immediately wrong or immediately correct to say that the president must appoint. The public protector makes an argument, and the argument is simply this: I think that the president is too conflicted in this issue, therefore it should not rest on the shoulders of the president to appoint a head of inquiry. That should then fall on the head of the Chief Justice, right? And she understands that that thing can be questioned in court, and this is why the president is questioning it in court. We now have an answer that says that, yeah, the president shouldn't be doing it. The president still has grounds to appeal. And the president, I think, should make an appeal in this instance, because I think, at least from a tonality point of view, I think that something came quite wrongly off on that judgment. Yeah,
let's get a view from Mosiri Tsiane from Mosiri Tsiane Attorneys. Good evening to you, and thank you for joining us. Where's the ambiguity when it comes to the constitutional executive rights of the president in appointing a judge in the commission that he would set up?
To be honest, I really don't understand what this judgment really says and what it intends to achieve, because all in all, we would assume that after all, in terms of fairness, that the president, if he needs to appoint, those powers are given by the Constitution, and those are the prerogatives that lies in that office. Forget the man, forget Jacob Zuma, forget whoever is the president, whether he's Thabo Mbeki, whatever president you can come up with. But the fact remains that these powers remain in that specific office. Now, to always refer to a point of law to an individual, that's one thing that is made as a mistake. We look at the man, we didn't look at the principles. For argument's sake, the president would, in this instance, go and make an appeal, whether it be that he wants to view or review this matter in a constitutional court because it is a constitutional binding or it has an impact on, in fact, with constitution. Now, be that as it may, it refers to judges, the appointment of a judge in that. Now, what are the judges? What if the judges themselves are conflicted in that? So we shouldn't find a judgment that will take us by and large to an extent that we find our country becoming ungovernable because of the decisions we make. We look at the man, we do not look at the law and the principles in that. There are many, many inquiries that were done by presidents who has appointed independent judges. Currently, there is one where a judge, a former judge of the Constitutional Court, is being appointed to overlook at the case, the question of Many, who says that as that instance is not affecting the government at large. The name of the government is being put at reputation. We cannot ignore that fact. Now, at large, at all times, are we always going to say that there is a complication matter because there is a particular person that we put the name in there? We can't find it like that. It is wrong. The judgment cannot be correct in our Constitution. Let the president appoint, and that judge who's going to be there, we always would assume that they are fair in whatever institution that they'll be doing, whatever investigation they'll be doing. No judge will be biased. The assumption given is that if a president is to appoint a particular judge, that judge will be more biased towards the president. What insinuation are you saying to all the judges, including yourself as a judge who's because you have been appointed by the president?
All right, Mr. Ngubeni, just your view on that particular point, that the presupposition that if Zuma were to appoint a judge, that judge would be conflicted. What can you read out of this judgment or the remarks from Judge Mlam?
Yeah, again, you see, there is a problem where the attempt here is to micromanage what the executive is constitutionally entitled to do. The question of appointment by the president, particularly by President Zuma, even the Chief Justice himself was appointed by President Zuma. Remember, there was a big furor about him having appointed Chief Justice Mogoeng. Now, today we are told that because the president is conflicted, he cannot appoint a judge, but a judge that he appointed should appoint another judge. I mean, the absurdity of it all, when you think about it, it doesn't end there. The question is whether, given the presumption of impartiality and judicial independence, in other words, our judges are all presumed to be equally qualified and to be free, independent thinkers, and to be impartial in adjudicating disputes. So whether President Zuma chooses a judge in the Western Cape or in Gauteng or anywhere, that judge comes in clothed with that presumption of independence and impartiality. It doesn't matter who his appointer is, whether it's the Chief Justice or is the President. That judge comes in close with that presumption of impartiality and independence. If that judge is faithful to the Constitution, he will do what an impartial and independent judge does. He will not be beholden to the person who appointed him.
But knowing that the public protector's remedial findings or resolutions are binding, if she recommends that in light of the proximity of closeness that the president has to the case of state of capture, therefore he's conflicted and the process in itself would be compromised, you know, a judge must appoint. Is that permissible in light of not only the Public Protectors Act, the Constitution and the executive prerogative of the president?
It's not permissible to violate one constitutional principle in order to vindicate some other section of the Constitution. The public protector's remedial powers are spelled out in the Constitution, and the limits thereof are spelled in the Constitution. So is the president's executive power, or the president's power as head of state and as head of the executive.
All right, please hold on, Mr. Ngobeni. A response from you, Mr. Dixon.
Just quickly, to say that the president is so closely, has such close proximity to the case, therefore the president shouldn't be in a position to appoint because the president is conflicted, is a reasonable argument to make. But you don't just make that argument and assume it stands. You have to compare the substance of that argument, compare it to the substance of another argument, that judges and the judiciary, by and large, has a presumption of integrity, has a presumption of impartiality. You have to then prove substantively that the president's proximity to the case supersedes one and suspends directly the integrity and impartiality that actors and officers of the law has in this instance, i.e. appointing a judge in this instance. That comparison wasn't made in Thuli Madonsela's draft of the state of capture report. So that comparative should have been made in the court of law. It still wasn't made in the court of law in this instance, and so the judge upholds it. I'd like to see that comparative happening because it's true that the public protector is in no position to direct the president on what to do because the president has the benefit of exercising executive power. But there can be an exceptional circumstance where the president, where that can be suspended. They then have to make the argument for why this particular instance is so exceptional that that has to be suspended. That argument also hasn't been coherently made in this instance. So I don't think there's enough substantive ground to uphold this ruling in this instance. Again, I could be wrong in this instance. This is why it's going through a review process.
Let us put it to Mosiritsiana here, and indeed, whether Mr. Dixon has got a point that if there is substantial evidence, allegation, suspicion that the president is compromised based on the state of capture report, therefore his parties can be relinquished, if you like, and then the judge makes a decision on what the best way forward is. We'll start with you, Ms. Mosiri. Hi, Mosiri. Okay, I think we've lost him there. Let's go to Mr. Ngobeni, if you're still with us. Is this indeed what the powers of the public protector translates to? That if there's evidence, sufficient prima facie evidence that the president is conflicted, therefore he relinquishes his executive authority?
So the public protector are not untrammeled either. They have to be exercised within the limits of the Constitution. You cannot require another person who's clothed with constitutional powers to relinquish their constitutional duties and functions in order to effect the so-called public protector's remedial action. Here, the issue of whether the president is conflicted or not is premised on the notion that he was somehow involved in this so-called state capture allegation. Now, to set up a commission, an independent commission of inquiry headed by a judge, does not require that the president be totally removed from that process. Because what has not been answered, and what Judge Mlambo and the public protector have not dealt with, is the constitutional requirement that at the end of the day, that state capture report that the commission of inquiry will come up with and the recommendations are supposed to go back to the president, who will then accept or reject them. That is the law. So this notion that if he is conflicted, he cannot appoint the judge, you haven't answered the question of what happens when the investigation is concluded with the recommendations. We are still back to square one. That is, he is still going to be playing a role. And that role in accepting or rejecting the report is much more greater than the role in simply setting up a commission headed by a judge.
So either way, it still
let me
depends
just say, I agree with one of your speakers who mentioned that there's this thing about personalizing this matter simply because it's Jacob Zuma. They wanted to make sure they get at him. And even where the argument, where the law is clear, you somehow look at it with a jaundiced eye because you know it's Jacob Zuma. But there has not been careful thought given to the entire process, even by the judge. Because he's talking about appointment of a judge to head a commission, but he has not talked about what happens after the commission is done with its work. It doesn't alter the constitutional role of the president in accepting or rejecting that same report.
Going to play out, and I know I'm preempting a lot because it's a case that has been dragging for quite a while, in the sense of if the president doesn't appeal, he would then have to set up the commission in 30 days and go accept the findings or the recommendations of the public protector. Is that correct?
If he doesn't appeal, definitely that means that he has to comply with the court judgment. But if he appeals, it automatically stays the judgment of the court until a higher court speaks out on this matter. And just one of the things that people keep saying that Jacob Zuma lost, the president, like any other public official, has a duty sometimes to seek clarification from the courts. This review application was in part based on the need to provide clarity on matters that are still unclear legally. So he is duty-bound, he's constitutionally bound, sometimes to litigate matters, to go to court and appeal if need be, so that we can get clarity from our judiciary.
All right, Mr. Ngobeni, thanks so much. A legal expert joining us on the line. Very briefly, Mr. Dixon, whether, just to pick up on...
Yes, I think that last point was very important, that the president, time to time, should be seeking declaratory orders, at least, or something of that equivalence from the courts on certain matters, and shouldn't just act rashly. And, you know, the court, somewhere in the court judgment, the Judge Mlambo says the president was ill-advised and lacked foresight and should therefore bear personal cost. I think that's a bit too harsh of a statement, given that the president came and said, look, we don't understand where the law stands on this, give us clarity on this instance. But lastly, and importantly, this commission of inquiry into state capture is going to happen. The terms under which it happens is quite important for the success of this inquiry. And I think we should be able to set up a commission of inquiry that knows the terms of reference, is quite clear and plays fair to all the stakeholders.
Absolutely agreed with you. Thank you so much, Oliver Dixon, political analyst, and Paul Ngobeni, legal expert, and Mosiri Tsiane, an attorney, joining us on the phone line. Thanks for watching. We take a break. We'll see you shortly.